Hello everyone, and welcome to this session on remedies in judicial review proceedings and wider objectives. I'm Katharine Elliot and this is Leon Glenister. I'm going to start off talking through the maybe more boring bit about remedies that are available in the proceedings. Let's start with quashing orders. Quashing orders are orders which overturn the decision or action that has been challenged in the proceedings, and traditionally those orders have retrospective effect. However, everyone is very pleased to know the Judicial Review and Courts Act 2022, which has come into force in July, has introduced the concept of a suspended quashing order. And this means that the courts may make a quashing order and suspend it to a specific date. They may also remove or limit the retrospective effect of that order. Now, they can't do this in any case. There is a specific list of considerations that they have to look at when deciding to do this. What that will actually look like in practice has yet to be seen, and we all look forward to that in due course. What happens after a quashing order? Now, there's two possible options. The court can either remit the decision, that means send it back to the person who made the decision or took the action, so that they can think about it again and hopefully do it on the lawful basis this time. Or in specific circumstances, they can substitute the decision for their own decision. Very specific circumstances now, so the decision has to be made by a court or tribunal, not any other body. The decision has to have been quashed because of an error of law, and the court or tribunal which made the decision must have only had one other option to take if they hadn't made the decision based on the error of law. So turning next to prohibiting orders, this is effectively the reverse of a quashing order. It prohibits a future unlawful decision or act from taking place. Moving swiftly on, we have mandatory orders, which are exactly what they sound like, an order requiring a body to take specific steps. This is normally sought in cases where a body has failed to do something which it is lawfully required to do. Finally, then, we have declaratory relief, which is usually sought in combination with one of the orders I've already mentioned. It sounds complicated. All it really is a statement of the correct law, which is made by the court effectively to guide the public body in question to do lawful things in the future, and other bodies. Finally, we have declaratory relief. That sounds more complicated than it is. Effectively, it's just a statement by the court recorded as a declaration in the order of what should have been done to comply with the law, and that applies to both the public body whose decision is being challenged and also to other public bodies. It's sort of guidance, and declaratory relief is often sought in combination with the orders that I've already mentioned, for example, in combination with a quashing order. Very importantly, and very differently from other areas of law, there is no independent right to damages in judicial review proceedings. Although, to put it very briefly, you can go on for ages about this, you can try and claim damages if you're also Importantly, unlike in other areas of law, there is no freestanding right to damages in judicial review proceedings. However, to put it very briefly, you can try and pursue damages to a limited extent if you're also pursuing a claim under the Human Rights Act 1998. It has to be borne in mind that all of these remedies are discretionary remedies. That means that even if you do everything you have to do, make out your substantive grounds at the final hearing, you might not then get the relief that you want, or any relief at all. And the court can decide to not grant you that relief on a number of grounds. It can do so because it doesn't think that the error would have made any difference, any substantial difference to the outcome. So basically, even if the mistake hadn't been made, you still would have had the same outcome. Another reason why you might not get the remedy that you seek is if you've unreasonably delayed in bringing the claim, and that is because that delay may have caused events to happen which, if you hadn't delayed, would have been stopped, and other people have acted in accordance with the decision that you didn't challenge on time, and their interests will be adversely affected by the relief that you seek. Or the delay might mean that there's bad effects for the administration of justice. So those, in summary, are the remedies available in judicial review proceedings. I will now hand over to Leon, who will talk to you about strategic considerations that you might want to think about when bringing your own proceedings.
Thank you, Catherine. Yes, so I'll be looking at some of the wider objectives when you're exploring whether to bring a judicial review or not, or how to defend a judicial review. And in any case, any legal case, you have to differentiate between the client's objectives and the legal claim, because they can be different. In some areas of law, they're quite directly related. So in a contract claim, for example, you'll be saying, I owe £10,000 under the contract, and the court will order the payment of £10,000. But in judicial review, it's a bit different, and the relationship between objectives and the legal claim can be a bit more indirect. And I'll cover and unpack that, if I can, in 3 areas. So the first area is the main remedy being the quashing order. So in general terms, if a claimant succeeds at a judicial review, the court will grant a quashing order, rendering the decision void. I can unpack that a bit further in terms of academic text, but for these purposes, let's leave it as a void decision. But that doesn't necessarily tie the hands of the decision maker when they come to retake that decision. So we put that in real terms. For example, if you are residents trying to stop the demolition of a housing estate, even if you succeed on a judicial review and the decision to demolish is quashed, it doesn't necessarily mean that the council can't still demolish it, taking a decision lawfully. Or if you are local residents challenging a decision of an NHS body closing a hospital, you may succeed in quashing the decision to close the hospital, but it doesn't necessarily stop the trust or the other NHS body retaking the same decision when it comes to look at the matter again. There are some exceptions to that. So if a court finds that a decision was irrational, it'd be very hard to see how that decision could be taken the same way. And also, and this is where convention rights can be quite important, if a particular decision breaches an individual's convention rights, then again, it would be very difficult for that precise decision to be taken again. And the same applies for discrimination under the Equality Act. So those are quite powerful tools in judicial review. But does the limited power of the quashing order necessarily mean that judicial review is pointless? Of course it doesn't. Whilst it doesn't automatically lead to a particular outcome, usually, it does constrain the scope of decision making that a decision maker could come to. And for political decisions or in challenges in the public interest, it can sway the political mood, and that can be very important. So, for example, when the Supreme Court found that Boris Johnson was unlawfully prorogued Parliament, theoretically he could have remade the same decision, but by then the political mood had swung, so it can be still relevant. And sometimes there may be very different reasons for challenging. You may, if you are challenging, for example, a planning decision, be seeking to delay that decision, and bringing a claim is a very good way to delay the implementation of a decision, stop any building work starting. And so that can be quite a powerful reason for bringing a judicial review as well. It may also be, if you're acting for example, a campaign group, that a specific part of the campaign is bringing this judicial review. If you bring a claim, it attracts news items when the claim is issued, when there's a permission decision and a substantive hearing, which can be all important for campaign purposes. So there are many reasons why judicial review is a very useful tool, but you just have to be careful in terms of how that relates to objectives. The second point to touch upon is the lack of financial remedy in judicial review. So judicial review doesn't of itself provide a financial remedy, although there are some circumstances where you can get damages in the public law arena, which Catherine has already spoken about. But that's not to say that a particular order by a court, by the administrative court, doesn't have financial consequences. So I'm sure you'll remember the case of Coughlin about substantive legitimate expectations, where a care home user was promised a home for life. Now, upholding that expectation inevitably had financial consequences for the local authority who had to keep the care home open. So there can be implications. Another example might be where you're challenging an award or a benefit. So showing entitlement, again, might have a financial consequence, although it's not directly a financial remedy. The third area in which I was going to cover was looking at the wider implications of a decision and thinking about knock-on effects of a particular judgment. So you may be familiar, particularly in social security cases or immigration cases, where there is a test case which other cases are stayed behind, and that is the kind of case which obviously has knock-on impacts on others. Now, that may affect you as a claimant, but importantly, if you're acting for defendants, so whether that's local authorities or central government or any other dependent, you might need to think about how you're defending a judicial review and how that might impact on a line you may want to take in another case, because as a public body, you've got to be consistent in the way you defend case, in the way you act. So thinking about those wider impacts is important. Drawing those together, it's always important to think about whether judicial review is the most suitable way forward. And it's worth thinking about, and it's often not relevant, but it's worth thinking about the alternatives. So I'll give you some. So for example, ombudsman. So you've got various ombudsmen in different arenas, and those processes can be very helpful for various reasons. One is that they can look at the merits of a claim and generally look at whether there's been maladministration. So it goes into the substance and not just the procedure, which is what the court does. Also, they're much cheaper. So there is no cost risk. There's no chance you'll have to pay the other side's costs. And that can be quite attractive. It obviously is generally lower profile than a court case, but it's something to consider. You may also look at statutory appeals, so those will generally have to be pursued anyway before going to judicial review, because judicial review is a remedy of last resort. You may also want to consider appeals. Statutory appeals often exist in relation to particular decisions. In fact, you will probably have to go down those routes before going to judicial review, because judicial review generally has to be a last resort. So it's something to consider. And again, they can often be cheaper because there's no cost risk on the other side in many of those areas. And sometimes it may be thought that actually, if there's a political issue, a campaign or something similar might be more appropriate than a judicial review claim, because one of the things, as has been touched on in other videos and we've touched on here, is that judicial review is about process rather than substance. So if the real challenge is substance, it may be political campaigning is a better route for you. So thank you for watching. Katharine and myself talk about remedies and the wider objectives, and we hope you found it helpful.